Thanks to Shopify for supporting Future Hindsight. Shopify is a platform designed for anyone to sell anywhere, giving entrepreneurs like myself the resources once reserved for big business. Sign up for a $1 per month trial period at shopify.com/hopeful, all lowercase. And if you want to support Future Hindsight, you can. Join the Civics Club on Patreon for early access to episodes every week. Head to patreon.com/futurehindsight to sign up. Welcome to Future Hindsight, a podcast on a mission to spark civic action. I'm your host, Mila. I'm a global citizen based in New York City, and I'm deeply curious about the way our society works. So each week I bring you conversations to cut through the confusion around today's most important civic issues and share clear, actionable ways for us to build a brighter future together. After all, democracy is not a spectator sport. Tomorrow starts right now. Most Americans feel that the Supreme Court stands for justice. In reality, the Supreme Court acts like a rogue branch of government. It increasingly operates outside established legal frameworks and threatens the democratic foundation of our legal system. To unpack just how the Supreme Court is lawless, we're joined by Leah Litman. She's co-host of the Strict Scrutiny podcast, professor of law at the University of Michigan, and former Supreme Court clerk, and the author of Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Welcome, Leah. Thank you for joining us.
Thanks so much for having me. Super excited to be here.
So I want to start with the subtitle of your book, which is How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Tell us more about what you're referring to here, because, of course, there are honestly so many things in this moment across the spectrum on the right. But when it comes to the Supreme Court, what are those grievances, theories, and bad vibes that animate it?
So the subtitle is definitely meant to be evocative. By vibes, I really mean to draw a contrast with how people think of as law. They think of the justices as doing something that's almost scientific or technical, that they can discover and discern right answers. And I'm someone who believes that there are sometimes right answers in legal cases. It just so happens that these justices aren't doing that or following it. They are instead following their feelings and imbuing the law with their emotions and the general vibe of the Republican Party. So that's the vibe portion of the subtitle. And then I also happen to think that a big vibe of the modern Republican Party is this conservative grievance mindset where they think they are victims of laws they don't agree with, or they're victims when people criticize them. And I can see that worldview very much stamped in so many different areas of law as well. And in part because the Republican Party has leaned into this conservative grievance mindset and been willing to appeal to an increasingly narrow segment of the country, that has pushed them toward fringe theories that aren't shared by a majority of the country, and that leads them to lean into opportunities for minority rule. And this is just a vicious cycle that is cannibalizing the law as we know it.
Well, I feel like where this is most evident is in the way that they rule in terms of voting rights and such. So, of course, Future Hindsight is a pro-democracy show, and we have already known for a long time that the Supreme Court is really no friend of voting rights. And reading your book, I actually learned that Republicans have been working to nullify the Voting Rights Act for decades, which I was not really aware of. So there's a long line of justices that have been instrumental in shaping the thinking behind how to undo the VRA. And finally, of course, the Supreme Court had the opportunity to do that in the Shelby County case to throw out preclearance. So the way that I think about it is that Shelby County was the decision that broke the dam. It's easy to say that it's anti-democratic, but how exactly is it anti-democratic? How does it disrupt American democracy?
How can I count the ways? There's a reason why Shelby County versus Holder is actually the case that I used to write my job market paper when I was starting to become an academic. And there's a reason why it's literally the backbone of this book, Lawless, and features as the big case for that middle chapter on voting rights. So Shelby County, in my view, inverts the traditional story that many people have of the Supreme Court, which is this idea that the court protects minorities who are unfairly victimized and hurt by an overeager majority and political process. But in Shelby County, the court kind of did the opposite because there Congress had adopted this law, the Voting Rights Act, renewed it several times, and that law protected racial minorities and language minorities' access to the political process and their political representation. So that's the law the Supreme Court blew up. Why is that anti-democratic or undemocratic? A few different ways. One is, I think, undermining protections against voter discrimination, making it harder for people to participate in the electoral process. That is undemocratic, anti-democratic, because it makes institutions less responsive to people's preferences and makes it harder for majorities to actually win political power. So that's one thing. Second is, I think it's undemocratic because the reasoning in Shelby County recycled losing political talking points against the Voting Rights Act. So it's this very pointed example of the Republican Party losing this fight in the political process for very legitimate reasons, and then the Republican appointees on the Supreme Court basically coming back and doing what Republican politicians weren't willing to do, which is nuke this crown jewel of the civil rights movement. Those are two ways. I could go on, happy to elaborate on either of them, but Shelby County is very undemocratic in my view.
Yeah, 100%. Well, one of the things that I thought about when I was reading your book is I just didn't realize that Republican presidents have agreed, or to say agreed, that sounds wrong. It's like saying, I invited you to tea and you agreed to come. But Republican presidents have signed this into law repeatedly and extended the VRA. But actually, all along, they've been trying to undermine it in a way that I did not fully comprehend until I read your book. And what also surprised me was that the ISLT, the Independent State Legislature theory, actually came from somebody on the court. And I feel like together with the ISLT and Shelby County, it's really not just anti-democratic, but really an effort to dismantle democracy. And so can you talk to us about how does all of this actually fit together?
Yes. So I just want to elaborate on something you said about the Republican presidents being willing to sign expanded, amended Voting Rights Act while basically surreptitiously behind closed doors trying to identify nominees who would strike down the Voting Rights Act. I think that adds another anti-democratic, undemocratic angle to this story because while on one hand, in public-facing remarks, they are saying, yes, I'll sign the Voting Rights Act. You persuaded me. It's clear where the public stands. Behind closed doors, they are telling potential supporters, I'm going to appoint justices who are going to stand up for the South by striking down the Voting Rights Act. And indeed, that is what happened. So it's this very behind closed doors, out of the public sight story of the demise of the Voting Rights Act that adds to the anti-democratic flavor of the story. I think what unites Shelby County and the Independent State Legislature theory and the other voting rights topics like partisan gerrymandering or racial gerrymandering is they are all efforts to make our institutions less democratic and allow the Republican Party to write a set of rules that facilitates them staying in political power even when voters don't want them there. And so the story I tell in the book is not a happy one, and I think it seems bleak in part because the Supreme Court has made it so. They have made it more difficult for majority coalitions to use elections to take back political power.
Yeah. Well, the Supreme Court loves to meddle in elections, not only on voting rights or districting and gerrymandering, but also on campaign finance.
Oh, yeah.
So Citizens United is perhaps the most consequential decision on campaign finance, opening the floodgates to billionaires and corporations to influence outcomes. What is the logic here? Because I think from the outside, people said, I've heard this repeatedly, the far right has spent billions of dollars even before Citizens United. But so exactly how does Citizens United change the game?
So I think it changed the game in two ways. One is the reasoning in Citizens United made it basically prohibitively difficult for Congress to address certain kinds of corruption that didn't satisfy the Supreme Court's definition of corruption. Because in Citizens United, what the Supreme Court says is Congress has a good enough reason to restrict speech, here money in politics, when it is preventing quid pro quo bribery, basically an exchange of money for a particular favor. But the court continued, what Congress basically can't do is address influence or access schemes where people pour in a ton of money and that money generates feelings of goodwill, secures them influence over politics or access to political officials, because in the Supreme Court's view, that kind of influence and access can never be corrupt, even when it is purchased. And they have these stunning lines in the opinion, like, all of this money, that doesn't lead to corruption. It doesn't lead to the appearance of corruption. It won't cause Americans to lose faith in our democracy, when, of course, the reality is something quite different, as we were pointedly reminded of in the 2024 election. So that is just one of the ways that Citizens United has really undermined democracy by unleashing this money in politics. But it's really the combined effect of Citizens United and these other decisions that has resulted in this wild, wild world of individuals who are super rich being able to spend however much money they want, and for people not to even be able to know about it. They can form super PACs where they can contribute as much money as they want to them. Those super PACs can then spend as much money as they want, as long as they are not contributing to a campaign and they are making their own messaging. And no one might be able to know where the money came from because it's dark money. And there are restrictions on, what kind of committees or organizations can be required to disclose their donors. So I think all of that creates this shadowy network that is difficult to pin down, even though it is pervasive and really shaping people's perceptions and views.
Well, we didn't get here overnight. You mentioned, of course, that Republican presidents have been appointing justices exactly to achieve the kind of outcome we have today. So it takes years and years of politicking to achieve the current makeup of the Supreme Court. And as a reminder to the audience, we interviewed Adam Cohen in his book, Supreme Inequality.
So
which
good.
is a great book, right? And he argues that the court has largely been unjust, actually, with the exception of the Warren years. I think it isn't really evident to the casual observer, which is something you just said also, who the justices are. But we definitely think we should all know more about who they are and how they got there. So tell us more about who's on the court today and sort of like, in the art language, what's their provenance? How do they get to sit on the Supreme Court?
Well, we were talking about the independent state legislature theory a little bit more. That was this idea spawned in Bush versus Gore, the decision that resulted in the Supreme Court ordering Florida to certify Bush as the winner of the presidential election in that state and therefore the country. There are 3 members of the Bush campaign legal team on the Supreme Court now: Chief Justice Roberts, Amy Barrett, Brett Kavanaugh. All of them worked on the Bush campaign legal team that successfully got the Supreme Court to stop the count back in 2000 and declare Bush the winner of the presidential election. And Chief Justice Roberts got on the Supreme Court because Bush was elected president. So that is mighty convenient. The other, individuals who are on the court all have a background in Republican politics. I could go on about Kavanaugh's role in the Bush White House. He also worked there in addition to on the campaign legal team. In addition to him, Sam Alito worked in the Reagan Department of Justice, where when he was applying, he basically said, my interest in constitutional law stems in part from opposition to that progressive Warren Court you were referring to just a little bit ago, and specifically their decisions that made the country more democratic, like the one person, one vote principle. So that's how he applied and got the job in the Reagan administration. Add to that Neil Gorsuch. Gorsuch was also working in the executive branch during the Bush administration. He famously was involved in some of the decisions concerning Bush's treatments of enemy combatants and detention and interrogation matters. Clarence Thomas, of course, served as a Republican commissioner nominee in the Equal Employment Opportunity Commission. So these are all individuals that have very apparent backgrounds in Republican politics, and yet people miss that during their confirmation hearings, and they oftentimes forget that or obscure it when reading about their decisions or analyzing them as justices.
Yeah, I feel like it is obscured. I really feel like the media is not really helping us understand where these justices are coming from and how a lot of these decisions are basically pre-decided, previously decided even before the cases come to the court. I have a question about judicial review. In past conversations on the show about the Supreme Court, we have essentially assumed the concept of judicial review as a given, but we've never really explained it. And you write in your book, quote, in 1803, in Marbury v. Madison, the court declared that it had the power of judicial review, end quote. Essentially, it elevates the Supreme Court as a more powerful branch than the legislature and the executive. So what exactly is judicial review? How is it used? And what kind of special power is that?
Judicial review, as I use it there, refers to the court's power to decline to enforce or apply federal statutes on the ground that they are unconstitutional. So basically, Congress passes a law. Presumably, Congress thinks that law is constitutional. Then the case is challenged, the law is challenged, it goes to the Supreme Court. The Supreme Court says, no, that law is actually unconstitutional, therefore no one has to apply it, and the law doesn't have force or effect. So that's what judicial review means. As you noted, the book explains how it originated in Marbury versus Madison. What people might not know is that the second time the Supreme Court ever exercised the power of judicial review was in the infamous Dred Scott case, when the Supreme Court invalidated and held unconstitutional the Missouri Compromise, and specifically the portions that restricted slavery in the new territories. So it wasn't a power that was used regularly for significant periods in the Supreme Court's history. We've become accustomed to it over time and gradually, I think in part because in our minds, the Supreme Court's power or ability to stand up against the political branches is associated in so many people's minds with the Warren Court, and the Warren Court standing up against segregation and Southern opposition to integration, that we assume that is just how the Supreme Court usually exercises the power of judicial review, when the history is way more complicated than that.
Well, we find ourselves in a moment of history where things are being challenged constitutionally, meaning people are wondering if it's constitutional or not. And philosophically, I'm wondering why it really matters, right? Like with the background of a lawless administration in the White House, which is notably engaging in the unlawful detention and deportations of people on U.S. soil, and is also endeavoring to get rid of the writ of habeas corpus, and, of course, the backsliding of democracy worldwide. What does it mean for the Supreme Court to be lawless?
Doesn't mean anything good. I think it is very terrifying. The way I try to explain it to people is something like, of the issues you just described, can the president deport people without due process? Can he basically designate certain people as just threats to the country? Can he decline to spend funds that Congress has appropriated? There is now genuine uncertainty about what the Supreme Court will do in those cases, which in some ways is the most damning indictment you can make of the Supreme Court, the idea that it wouldn't be a unanimous decision telling the president, of course, in order to render someone to a foreign country, potentially irrevocably, you need to provide them with due process. The idea that that could be 7-2 or 5-4 or whatever should be shocking. So what does it mean for a Supreme Court to be lawless in this era? It means a government that is potentially not subject to the rule of law. It is no longer a government of laws. It is a government by men. And I think the Supreme Court has played an important role in enabling this administration to be acting in the ways they are through prior cases like the immunity decision or their expansive views on executive power. I think many different C's of what the Trump administration is doing are related to things the Republican justices on the Supreme Court have been saying and doing for a while.
Mm-hmm. We'll be back with Leah Litman in just a moment, so stay with us. You can't miss this episode's Civic Spark. One small step we can all take to be more empowered and ignite collective change. But first, Future Hindsight has been coming to your ears for almost 8 years. And it's safe to say we found our groove. But in the early days, it wasn't so easy. It felt like I had to figure it all out on my own. Whether that was finding guests, recording the episodes, editing everything, you name it. It can be an overwhelming feeling when every day seems to introduce another question that needs an answer, right? Anytime you're starting something new, it's like your to-do list just grows and grows with new tasks every day. And that list can pretty easily take over your life. So how do you find the right tool that not only helps you out, but simplifies everything? Because that can be such a game changer. For millions of businesses out there, that tool is Shopify. Shopify is the commerce platform behind millions of businesses around the world and 10% of all e-commerce in the United States. 10%. From household names like Chamberlain Coffee and Rhode Beauty to fresh brands that are just getting started. So, if you want to get started yourself, take the first step with your own design studio. With hundreds of ready-to-use templates, Shopify helps you build a beautiful online store to match your brand's style. And if you want to accelerate your content creation, Shopify is packed with helpful AI tools that write product description, page headlines, and even enhance your product photography, if that's your thing. With all of these great tools at your fingertips, you can get the word out as if you have an entire marketing team behind you. In just a few quick minutes, you can easily create email and social media campaigns wherever your customers are scrolling or strolling. It's so great to know that Shopify is your commerce expert with world-class expertise in everything from managing inventory to international shipping to processing returns and beyond. If you're ready to sell, you're ready for Shopify. You know what I love about Shopify is that no matter how big you want to grow, Shopify gives you everything you need to take control and take your business to the next level. Turn your big business idea into cha-ching with Shopify on your side. Sign up for your $1 per month trial period and start selling today at shopify.com/hopeful. Go to shopify.com/hopeful. Shopify.com/hopeful. We also want to share about a podcast called Assembly Required. It's hard not to want to tune out the news these days. But despite how overwhelming things feel, we're not powerless. Our job now is to pool what we've got and see what we can make happen. At Assembly Required, Stacey Abrams will face each executive order, legislative policy, and every news cycle, no matter how terrifying or absurd, by asking the following questions. What can we do to learn more about what's happening? What can we do to solve problems, however small? And how can we find the kind of hope that can sustain our work in difficult times? Tune in to new episodes of Assembly Required every Thursday, wherever you get your podcasts, or on YouTube. And now, let's return to my conversation with Leah Litman. I am not a lawyer, and when I'm reading the news, I wonder, you just laid out how actually the Supreme Court has made the current environment possible, that even a case on birthright would be heard, or that Steve Miller can walk around saying habeas corpus can be dismantled somehow or made illegal or no longer effective in the United States. And when I talk to, at dinner conversations, to regular lay people, not in the law, casual observers, I feel like they continue to believe that the Supreme Court is eventually going to rectify the situation. But I really don't think that's true. I don't think that's happening anytime soon. So in a way, if you could explain it to somebody in a nutshell, like what's happening right now and how they should no longer have faith in the Supreme Court, what would you say? What do you wish they knew?
Oh, where to start? I would start by informing them of the justices' biographies, as we were just talking about. I would want to talk to them about Bush versus Gore and Shelby County versus Holder. But I think what I would also want to say is some of the cases you were just alluding to, which is, look, the Supreme Court decided to put on its docket this case about whether courts can prevent the president from essentially repealing the first part of the 14th Amendment, one of the clearest provisions in the Constitution that was enacted to overrule Dred Scott, that Congress has repeatedly enacted into federal law. And the idea that we don't know how they're going to come out, or that decision isn't going to result in a 9-0 clear, simple declaration of obviously the president cannot eliminate birthright citizenship is evidence that something is deeply wrong in the Supreme Court. I would want to talk to them about the immunity decision. I would want to talk to them about the decision telling states you basically can't enforce the provision of the 14th Amendment that disqualifies someone for running from office if they have participated in an insurrection or rebellion against the United States. That decision cleared the way for Donald Trump to appear on the ballot and to become president again. I would ask them, what is the thing the Trump administration is doing that most concerns you right now? And then I would want to explain to them how the Supreme Court laid the groundwork for that, whether it is mass firing of officials, whether it is clearing house in the administrative state, whether it is attacks on voting rights, whether it is honestly a vindictive patriarchy, attacks on the existence of LGBT individuals. So many of these things, the Republican justices have been signaling their interest in for several decades at this point.
Yes, this is a question my 18-year-old is always asking me. How is it possible that Trump is on the ticket? And how is it possible that after January 6th, people even wanted to vote for him again? Yeah. But that's a different question about this rather than the Supreme Court. The Supreme Court, though, of course, made it possible for him to be on the ticket. So we have had many conversations about reproductive rights on the show, the Dobbs decision, et cetera, et cetera. And you have a whole chapter called The Kensurrection of the Court. And for the audience who listens to Future Hindsight, it feels like here we are again talking about this, but I do think it's important to call out the real-life brutality of abortion bans again and again. Which one of the stories that you write about in the book haunts you the most?
I don't know that I can pick one, and honestly, just picking the handful of stories that I did include in the chapter was already difficult enough. So the stories of the women whose lives were lost from abortion restrictions haunts me in certain ways that are difficult to convey. One reason is when the court overruled Roe and Dobbs, I think some number of people on the left, particularly men on the left, thought this is a political gift to Democrats. It is going to help them win elections. So yes, they overruled Roe, they eliminated constitutional protections, but the political fallout is just going to be immense. I never shared that delusion. It's true, it appears to have had some effect in the midterms, but then in the wake of ProPublica stories about women who died because of abortion bans, America put back in the White House the president who appointed the justices who overruled Roe. And I think people told themselves that the United States would be like Ireland, where when there was a single story of a woman who died from sepsis when she was delayed in receiving abortion care because of an abortion ban, that of course the same thing would happen in the United States. And we would flip back and there would be such outrage. That's not what happened. And so the idea that these women's lives and stories have just become costs and afterthoughts and did not mobilize some kind of mass public outrage at the cruelty of denying women health care, taking away their lives, taking away children's mothers, people's sisters, wives, friends, because you just wanted to regulate pregnancy, something that is way too complicated to be subject to these kind of legislative rules. That is deeply chilling to me because it says something quite dark about America's views on women and the kind of care the country has for women.
Yeah, I mean, I think the sexism in this country runs deep. But also I think there's a really deep disconnect between what people understand about the law, meaning like abortion bans, for example, and how it actually affects you every day. I think it's very difficult to understand. So I'm originally from Indonesia, and I love to tell the story because it just shows you how especially men really don't understand. And so I was sharing at this gathering before or right after actually Dobbs was decided that, abortion bans kill women and that, of course, the number one abortion by numbers is a miscarriage, abortion care as a follow-up from miscarriage.
Yeah.
It's a miscarriage treatment. And I was in Indonesia, where, of course, this is a majority Muslim country, very, very conservative, also does not believe in abortions, but you can get miscarriage care. You can get an abortion after you have a miscarriage. And the husbands at this table, they were just outraged. They just didn't understand how different the U.S. is. And I think this is what a lot of men really don't understand.
Yes.
That something very basic is being denied and very necessary is being denied. It's not like I think when people here in the U.S. think about abortion, they think it's a teenager who, got
had
pregnant out of wedlock.
Sex.
Right, exactly. That's not what this is.
Also, by the way, just having unprotected sex, right? A condition on that shouldn't be, and therefore you must birth a child. That itself is wild. But anyway, sorry to interrupt you.
Yes, I totally agree. I totally agree with you. So we have now talked a lot about the reality of the lawlessness of the Supreme Court. But so what can be done to reclaim it? Because there are plenty of ideas. And for this conversation, I thought we should talk about term limits and court expansion. To me, these are the bare minimum and probably, I think they're the starting point, let's say. So tell us more about how these reforms would help render a more just institution.
Yes. So I guess I want to start with a preceding point, which is in order to get at those reforms, I think we need to address something you and I have been talking about, which is the lack of public information and education about the Supreme Court. I think most people in the United States graduate from school with only a very limited exposure to the Supreme Court and understanding of the institution, and their image is that of the Warren Court. And they think that's how the court has operated for most of U.S. history. And so let's just leave it be and it will snap back to that. I think that is highly, highly misleading and not a great mindset to leave people with. And so the first step is public education, encouraging people to learn more about the court, talking to them about the court, figuring out how to get that kind of information out in our communities and make it relevant to individuals' political lives in the same way that other issues are relevant to them. Because no matter what you care about, the Supreme Court has the potential to weigh in on that in ways that you might not like and that might prevent you from accomplishing the goals and policies that you care most about. So that's one thing. And I think public education is just a super important step.
Totally agree.
Yeah. Term limits, Supreme Court expansion. When I say term limits, what I mean is a system that would define a term of a Supreme Court appointment as being 18 years. And so during those 18 years, a justice could hold their office for good behavior so long as they're not impeached. And in my view, doing term limits would regularize Supreme Court appointments so that when people go to vote in an election, they know, okay, I'm selecting a president and senators who are going to pick at least one, if not two, Supreme Court justices. Also, this prevents strategic retirements or unexpected deaths from resulting in sudden, dramatic, unexpected changes to the law, which I think is definitely something to avoid. So term limits are not going to alter the court that we have now, because I don't think Congress could apply term limits to justices who have already been confirmed. So when we're talking about term limits, that's more of a forward-looking perspective change that would change the institution over, let's say, a period of maybe 50 years or something like that.
How could you implement term limits? Is that something that is legislation that Congress has to pass?
Yeah, so there's differing views on this subject. It either has to be through a constitutional amendment that would define a term as 18 years, subject to these conditions, or through legislation that would just define the office and appointment of a Supreme Court as 18 years. My own personal view is that Congress could do that by legislation, again, as long as it isn't applying that to justices who have already been confirmed. But there is a debate about that. And I also think it is quite likely that if Congress did that by legislation, the current Supreme Court, the Roberts Court, would likely invalidate it because...
Right. That's the question I always have. It's like, well, they have this new law, but then the Supreme Court is just going to invalidate it. And then, like, why bother? Go through all the rigmarole to get the votes to pass a law. And then it's like, oh, never mind.
So two things on that. One is I think that's why you can't just do a reform like term limits or limiting the court's authority. You have to pair it with court expansion because they're not going to let you democratize the institution. So that's one thing. But second is sometimes I like to suggest to people that this fear of doing certain policies on the ground that the Roberts Court would strike them down is a form of obeying in advance vis-a-vis the Supreme Court in a way that many people find problematic with how institutions are responding to the Trump administration. So I say do it, right? Try to do it in a way that's effective. Make them spend their political capital in striking this down. And if you really believe they're going to strike it down, then obviously you should pair that reform with something else. But at a minimum, don't not do it just because you're worried they are going to interfere with it.
Right. Don't pre-capitulate.
Exactly.
So talk to us about what court expansion would look like. But actually, before we do that, I have a question about 18 years. So I've heard this 18-year number in a number of places. But why 18 years? Why not 10 or 8,
Yeah, so I don't like 8. I think that's a little low. I think the job of a Supreme Court justice is something where you do get additional perspective on the relationship between different courts, the functioning of the executive branch and Congress, and what is helpful for lower courts the more time you spend there. So I wouldn't want a term as short as 8 years. I'm not wedded to 18. I just mentioned that because it is the most common number that is thrown out. I don't care whether it's 14 or 10, anything longer than 18, I'm a little concerned about, but that is just why I picked 18.
Got it. Well, so let's talk about court expansion. What would that look like? How many justices are you thinking of would make sense to add, and how do you get there?
So how do you get there is the easiest. This is something Congress can absolutely change by legislation. The number of justices isn't fixed in the Constitution. Congress by law has changed the size of the Supreme Court repeatedly throughout history. So this can just be done by a law that Congress enacts. As to what I would want to happen by way of court expansion, my own view is I'm not personally scared of a Supreme Court that is especially large in size. I think some people sometimes warn against court expansion on the ground that that's going to result in a court that's 25 justices or 50 justices. And I kind of think, okay, if you're going to require that bunch of people to reach agreement on something in order to make law, maybe that's not the worst thing in the world. But at a minimum, I would start with a number of justices who would be sufficient to do two things. One is make it so the court wouldn't strike down pro-democracy measures. So I think at a minimum, that means expanding the size of the Supreme Court to 13, ensuring that there are 7 justices who believe Congress can protect voting rights and prohibit partisan gerrymandering. That would be where I would start.
Fair enough. All right. So we love to turn to what we can do ourselves. So every week on Future Hindsight, I ask my guest to share a civic spark, one small step we can all take to be more empowered and ignite collective change. So what's a good way to turn the insights that you've shared with us into action?
Do you have a book club or a reading group? I have a book to recommend to you, Lawless. It will give you and your friends a ton of information about the Supreme Court that you can then transmit to other people so that we can all serve as force multipliers for that information. So not everyone has to read it. Maybe pick one of your friends who will read it and then download you the Cliff Notes version. But I do think for those people who like to read, I'm obviously a huge nerd. I'm a law professor. I love to read. So I encourage people who are not necessarily the biggest extroverts to incorporate this kind of politics and education into a book club and then get the extroverts involved who will get that message out.
Awesome. I will say that your book is very accessible, very easy to read, and I love all of the analogies you use. It makes it really contemporary to our everyday lives, with your examples of the Bluth family of Arrested Development, one of my favorite TV shows of all time. It's so good. And of course, Game of Thrones. So I highly recommend that. And I have to add here that actually somebody else recommended your book to me who is a listener of your podcast. And this person happens to be an old babysitter of my children who are now, young adults. And I was like, wow, this is a random recommendation. But I just wanted you to know that people maybe across the spectrum that you would not expect are reading your book. So last question. Looking into the future, what makes you hopeful?
What makes me hopeful? Two things. One is seeing that the more information people have, the more Donald Trump's approval ratings plummet. The fact that he is underwater on immigration as the media and commentators have been putting front and center the stories of the men who were wrongfully expelled to El Salvador. I do hold out hope. I'm not a super optimistic person, I don't think, but that a majority of the country doesn't believe people should be expelled without due process, that women should be tortured within moments of having their lives lost for being denied medical care. So that gives me some hope. Second is the outcomes of state Supreme Court races. The fact that Elon Musk was not able to buy Wisconsin. The fact that here in Michigan, we were able to take one of the most conservative state Supreme Courts in the United States and flip it to a 6-1 progressive Supreme Court over a period of 15 years. You can make big change, particularly at the state and local level. So I think those wins are definitely things to celebrate.
Yes, hear, hear. Thank you very much, Leah, for joining me on Future Hindsight. It was really a pleasure to have you on the show.
Thank you so much for having me. I really appreciate it.
Leah Litman is the co-host of the Strict Scrutiny podcast, professor of law at the University of Michigan and former Supreme Court clerk, and the author of Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Remember, civic action doesn't have to be complicated. It's about small steps that spark progress, like sharing this episode with a friend. Let's recap this week's Civic Spark and fire up our collective power. We love this one because obviously we do this ourselves. Read books on issues of public interest like Lawless. And if you're in a book club, even better. Learn about the Supreme Court and its lawlessness and talk about it in your book group or even at the dinner table. Next week on Future Hindsight, we're joined by Erwin Chemerinsky. He's the Jesse H. Chopra Distinguished Professor of Law and the Dean of UC Berkeley Law. His latest book is No Democracy Lasts Forever: How the Constitution Threatens the United States.
I believe the choices that were made in writing the Constitution are now really haunting us. The Electoral College, 2 senators per state. I think it's all made worse by the House of Representatives being very gerrymandered, life tenure for Supreme Court justices, also being made worse by Supreme Court decisions that have allowed corporations to spend unlimited amounts of money in elections and gutted the Voting Rights Act, and choices that were made with regard to race and slavery back in 1787.
That's next time on Future Hindsight. Now, be sure to follow us on your podcast app so you'll never miss an episode. We're your resource for all the tools you need to stay engaged. So follow Future Hindsight now, and we'll come right to you every week. And if you want to support Future Hindsight and all the work that we do as an independent pro-democracy podcast, join the Civics Club on Patreon. Head to patreon.com/Future Hindsight now. Thanks for tuning in, and until next time, see clearly, act boldly, and spark the change you want to see. This episode was produced by Zach Travis and me.
This podcast is part of the Democracy Group.